Okay, which one's the main one to look at? That's Tony, that's us. Okay. All right, we're ready to go. Welcome to Divorce Cafe, the podcast where we demystify, detangle, and hopefully detox the legal processes that follow a separation with the experts in the relationship property world. Today, we are so excited to be talking about mediation. Mediation is a term that's frequently bandied about in the context of disputes, sometimes as a threat, and sometimes as a sort of a magical panacea, land of unicorns and magic. People go to mediation in the hope that that will be a circuit breaker, a way out of a dispute with as close to a happy ending as can be achieved. But what is mediation actually like? What can you do to best prepare for it? Where can things go wrong? And when you're both so far apart, is it worth even bothering? Today, we're thrilled to have been able to bring together for this episode a very distinguished mediator and former family court judge, and someone who was one of his clients and a part of one of his mediations, our own Shelley Fennell, to better understand the mysterious world of mediation. On the home team,
I'm Shelley Fennell.
And I'm Tiny Henderson. We are partners in life and partners in law and friends in life. We work with people going through a separation to navigate what is usually a complex and bewildering process. Shelley's a numbers whiz. She worked in relationship property until beyond when she went through her own relationship separation and experienced it all from the other side of the desk. I love working in this area of law because I think it's important work and I want to be involved in making it better.
Okay, so today's special guest was admitted to the bar in 1975 and was a family court lawyer who was very interested in mediation as a way of resolving family court disputes. In 2005, he became one of only 3 full-time barrister mediators in the country, and in 2014 he was appointed a district court judge with a family court warrant, correct? Yes.
Right.
As a judge, he continued to develop his mediation practice, overseeing judicial settlement conferences, and he became the National Resource Judge for Family and Civil Settlement Conferences, teaching best practices to other judges. He left the bench in 2017 to return to private practice as a mediator. He is the veteran of over 1,420 mediations and judicial settlement conferences. So I guess you can call him an expert. Lawyers and clients value him for his gravitas as a former judge, for his broad experience and knowledge of the law in this area, and for his 97% success rate in mediations.
He's so in demand that we're very lucky he was able to squeeze us in today, and we thank you so much. In between mediations, Tony Lendrum, welcome to Divorce Cafe.
Thank you. Thank you both.
The first thing we need to say is that Tony helped Shelley and her lovely ex-husband Damien to resolve their own relationship property division some time ago, and we've asked Damien, and he's given us carte blanche for Shelley to talk about her experience, but we won't be abusing that license today. We're not talking about numbers. We're not talking, yeah. So, do you want to handle the icebreaker, Shelley?
Okay, before we get into the juicy bits, in our first segment, we like to have our distinguished guest pick a random question from the distinguished bucket, which eludes us right now.
Yeah.
Tony, I apologise in advance for this because half the questions are insightful interrogations on life and the law, and the other half were made up by me.
Yeah.
So
I'm going to pull it out of the bucket for you because it's out of sight and say, your question, icebreaker question, you've been a lawyer, you've been a mediator, and you've been a judge. Which is best?
To be a mediator is the best of the best, without a doubt. Without a doubt. Clear. That's why when I reached retirement age, I turned down the offer to stay on for another 5 years with an acting warrant. I was extremely keen to get back to mediation, which has been the great professional love of my life.
Yeah, that's
Do you have why? Like, do you have one reason why?
Yes, because you can help people achieve an outcome that may not be everything they want, but gives them enough to start feeling that they can live again.
Yeah.
And that's based obviously on doing family law mediation, which is my primary area of work.
Yeah.
Okay, awesome. So if you're interested in finding out more about mediations, there's a lot of detail available in the show notes and links, and there's articles that are linked to this podcast. The next section is stuff we find interesting. Couldn't come up with a better title because that's what these questions are. It's exciting to talk about mediations because we don't hear about mediations in this way, lawyers or people in general. What they're like, how best to prepare, and after a mediation, often the lawyers are a little bit miffy about how it went. They don't think, they might have liked something to go, so they don't like post-morteming them. We get a chance to look today at what goes right, what can go wrong. So in terms of the first question I'm going to put to you is going to clear up the basics of mediation, which is, if we can jump in and put you right on the spot by asking you, what is mediation?
Well, that's easy. Mediation is simply having an independent person facilitate your dispute. That's really all it is. You have an independent person help you work through the issues that you have and normally achieve a result. Maybe not 97% now, but certainly 9 out of 10 or better.
Yeah, give it the best crack. Right, okay.
And I should say, of course, it's the only legal or quasi-legal process that can bring your dispute to an end, normally within a day, and it cannot be revisited. So there can be no appeal. And I'll talk about that.
Yeah, we can talk about those cases where, the mediations or decisions reached in mediation are challenged. Okay.
Yeah, there's really nothing else where you can walk out of the house in the morning and have the worst dispute of your life and walk back in the house at the end of the day.
And it's over.
Which incredibly is what happened to you.
Absolutely.
In your mediation with Tony. Yeah, so Matt, hopefully we'll hear a bit more as we go along. So talk us through a mediation, Tony. What's your process?
Process is very simple. I start with an introduction to the parties. I tell them how I see the mediation process working. When I've done that, normally 5 minutes, 7 minutes, something like that, just taking them through the key aspects of mediation. And then I'll ask the parties to tell me something, because I far rather hear from the parties and their lawyers. And then I'll ask the lawyers to give me some of the legal issues that might be involved in it. And then it's free flow. And every mediation is different because the parties are different. Even if I've got the same lawyers, the parties aren't the same. And so it just becomes a free flow, and there's no scheme. You just have to go on your instincts.
And as the mediator, what do you see as the mediator's role in a mediation?
To assist the parties to reach a settlement.
Whatever that, it's going to be different. And can you give us an example of where it might differ?
Well, it's just completely different because, of course, and something that I wish all lawyers who come to family law mediation would read is a Court of Appeal case from 2007, famous now, Hildred v. Strong, where the court said, the unanimous decision of the Court of Appeal said, mediation is not legal proceedings in mufti. It's a completely different process, but you can achieve a settlement which the court will find to be binding.
So equivalent,
providing
got
you
the
have your lawyers there, and of course I won't mediate without lawyers present.
And I think it is useful for the parties to know that that is what is going to happen. I think I did have some warning beforehand that I had the option of speaking. I didn't think I was going to, but it is, if you are preparing for mediation, I think it's good to kind of think about those main points that you want to get across without being too attacking, for want of it, or aggressive, to put forward your side of things. and kind of have those main objectives that you're trying to get out of it. And that's usually more emotional, isn't it, than the lawyers. It's like very personal. This is what's happened. These are the kids, or this is what I want out of it. This is what I value in you.
I love the emotion that comes, because that emotion is the best channeler, the best funneler of the process. And people who think they're cold and this is just about the money realise that it isn't.
It never.
It's about the breadth of their life.
Yeah, and I think having that, you just cannot even think about a resolution until each person gets to say their side of it. I think that's a really valuable part of the mediation process.
What is resolution unless...
Like for us, it was the first time we'd sat in front of each other for a really long time, and I know we had the lawyers, but we were, right across the table, and it's your chance to actually say your side of it, and then you can actually move towards a resolution, which is what a court process, I guess, is meant to give you as well, because you do all your affidavits or whatever. But it's a really easy way that you can voice in your own words where you're coming from and what you've experienced.
I agree, and of course you're never cross-examined. so you can speak, you can express your feelings, you express emotions, which are sometimes different, and you express your needs, and you cannot and will not be, I'm certain with all mediators, you will not be cross-examined in any way on it by the lawyer, even indeed by your former partner, or as in many of the cases I deal with estates, which of course is a very high-end emotional process. You cannot be cross-examined, so you've got security in your seat.
Are there any rules for mediations?
Yep, there are two that I abide by and one practice. The first is confidentiality, which is absolutely essential to the mediation process. Under the Evidence Act, that confidentiality is vested in the mediator. In all the mediations I've done, I've never breached confidentiality, although I've had some extraordinary circumstances. I never have. This next is private meetings, because a lot of mediations are convened on a basis that the mediator's passing between the parties. You obviously need to talk to your lawyer privately as you're going through the process. There's a double confidentiality on the mediator there. I can only really pass on a question of process or very happily an offer. And I have a rule of practice, which is one voice at a time. It's impossible to hear above a cacophony of voices. They're the only rules.
Yeah.
And so legally speaking, the parties sign up to it. Maybe this is a question later, but you sign up to it, and then that is enforceable by the courts against, or it's as enforceable as a judgment. So once you sign up to that mediation, you do a mediate. If you get a solution at the end or a resolution,
that's binding.
That's binding on the parties, and you can't appeal that to a court.
No, well, the court, you could appeal it, but you go nowhere.
Yeah.
Because the Supreme Court approved Hildred and Strong. It's just binding authority.
Yeah.
And now universally accepted by any experienced family lawyer and commercial lawyers too.
Yeah, has to be the way, otherwise
it's just a waste of time.
Yeah, it's a waste of time.
Yeah.
But it's the only way you get through something in a day.
Yeah. Okay, so what disputes do you think are most amenable to resolution by mediation in the context of what you're doing, obviously?
Well, I'm talking family law.
Yeah.
Commercial shareholding disputes are the best of the lot.
Oh, are they?
Through them by 3 o'clock in the afternoon. Because all they're arguing about is normally a bunch of men arguing about money. But my mediations are primarily high-end relationship property, estates and trusts. They're all amenable. But the best is probably estates, because the emotions are higher in estates.
Yeah.
And the rule of thumb that I've sort of worked out over the years, the more emotion in a situation, the more easy it is to manipulate, to help people see how they can work through it.
Yeah.
And estates are always interesting because, of course, in our society, you normally have dad who's passed away, and the
Partner,
stepmother realises that where she thought she was loved by the children, she was in fact hated. So you get terrible situations. But in fact, because it's not that direct, because, for example, my example, dad's dead, actually the kids just really want to know what they're getting.
Yeah, and then out and away.
Out and away.
Yeah.
Are there any situations when you wouldn't mediate?
Yeah. So I thought of that. A gross power imbalance, which is not always traditional male-female power imbalance. Of course, seriously bad domestic violence is not mediatable, because although to be fair, I have, but I don't think anyone thought it was a good experience. We got a result, the result stood, but part of mediation is having both parties in the room together at times, and you can't do that with gross domestic violence. So you've got one person in another room, and also it's very difficult in that situation for the man to feel that he's not being stigmatised, because of course you will both know that 99% of domestic violence in New Zealand is perpetrated by males upon females. So
I didn't know that.
It's over 99%, where it was when I was judging, and I'm sure it's actually worse now than better. So that's the only ones really, I think.
Okay.
Okay. When do you think is the right time to mediate? Is it better after proceedings have issued? And is there like a really raw time after a breakup when it's never going to work?
There's no right time.
There's no right time.
No right time. It depends on the parties themselves. Everyone's individual. It depends on that.
Do you think there's a wrong time though, I guess?
Well, a wrong time is when people cannot emotionally handle it.
Yeah.
But I always remember mediating with two of our top QCs, as they were then, over a reasonably well-to-do family. And the lawyers decided that they would go and have a talk, and they wanted me to talk with the parties by myself, which I did. And I do that, but that's only with the permission of the lawyers, of course, and the parties themselves. And at 10 to 12, so 2 hours after we started, they said, look, you talk with them for a bit on this issue, would you? And we'll go and sort something else on the property issues. I said, okay. And we sat talking, and the husband said to his wife, well, what do you really want? What do you really want? And she said, I want 1.4 million. And he said, I said, look, should we have a chat about this? Because there's a way to work through this called three blind mice. And we got to the first stage where in three blind mice you decide what you need to have, and we see if we work towards a common figure. 10 minutes later, we had an agreement, 1.35 million, and I went downstairs and I said to the two lawyers, I said, look, I'm sorry to bother your conversation, but they've settled. And the lawyer for the wife looked at me and said, that's impossible. And the lawyer for the husband said, that can't be. And I said, she's changed guilt to guilt. Guilt with a U to guilt without the U.
Gold-plated.
Gold. She's changed it from his guilt at going off with his secretary to her gold, and it was over. And they both said, well, it can't be. And I said, well, they came to exactly the same figure, and you go up and tell them they can't. And both QCs went back up and were wrapped, and we all went to have lunch.
Because I've always wondered about that. I've been told that it might be anywhere from 6 to 12 months, the guilt period after someone has behaved badly, and whether you can take advantage of that or not take advantage of it.
Yes, take advantage of it. No, take advantage.
Because they're open to resolution at that point, whereas...
your time,
yes,
you can actually get more movement.
Yeah,
than
like a
the
more
lawyers
realistic.
have put you in your trenches.
Yeah, like it's a more realistic kind of,
So I'm going to skip the mediator's role because we've kind of talked a little bit about that, but how should a lawyer best prepare for a mediation? What are the things that really make a difference?
Very interesting. First, prepare your client for a range of outcomes. Vital. Do not anchor. Anchoring is the mediator's term for where someone says, this is our position and we're not moving because we're right and you're wrong. And particularly avoid anchoring when you base it on what you know are your client's views, even though the client's ignoring reality, because the client's just impossible. And the last one that's actually quite important for lawyers in this process is to be polite to the other side. And but I think it's
not
vital.
Further entrench them.
Yeah. I think it's vital you prepare your client for a range of outcomes, because, as Justice Robertson said in Hildred and Strong, mediation is not court proceedings in mufti.
No.
It's a completely different process, and you have to be ready to look at completely different outcomes. And if you're a good lawyer, you can traverse that change from common normal practice.
Roll with the punches. Okay, so what can a party do best to prepare for a mediation? And a question that was really preying on my mind is, what do I wear to a mediation? What do I do to get ready? Like, do I want to be formidable, or do you want to, like, does it matter what the party does?
I don't think I've ever worried about what parties wear.
That's perfect.
The Northern Club, where I mediate a lot, does want some decorum, and that's been challenged at times, but I don't think that's important. So
what can they do?
I think the key thing, there are two that I think. First, be truthful to your lawyer, because the process, because the other side's there and they know their version of the truth that you have a slightly different version of, but enough. So be truthful to your lawyer, and also, I think vital now, require time with your lawyer no closer than 2 weeks to the mediation to go through a range of scenarios with your lawyer, and also for the lawyer with your client. Look at the range of possible solutions. It will never be what you dream it will be, apart from, of course, the apocryphal story I told a moment ago, where she did turn guilt to guilt.
She's still got 50,000 less.
Yes, but that was a very good result, believe you me, on the property that they had. It was 75% basically of the property.
Which presumably was a good outcome for him as well, because
he knew he could
all
rebuild.
Sorts of
He knew he could rebuild, and of course he thought, like so many people think, he'd actually found true love this time around.
Right.
I'm never not quite sure what their 2 children thought though.
Okay. So, what role do lawyers have in a mediation? And I guess more particularly, when have you seen a lawyer handling the medium particularly well? And what did they do?
Well, the first part's very simple. Lawyers are vital because you can't have an agreement without them. Because in the work I'm doing, it needs a lawyer's sign-off of relationship property. No lawyer is not going to have a legal sign-off on a trust matter. And estates, of course, someone's got to do the deed of arrangement and various other things. You've got to have a lawyer there, and it's got to be present at the time, and they've got to be present right throughout.
I guess they each need to feel like they've got what's fair, within,
3 QCs and 1 would have been a QC but is now a district court judge are my examples really of people. One of them opened in a particularly difficult estate case, 3rd wife, children of the first 2 marriages, 2 of the children with their own issues in one family, 2 brothers who were of the first marriage and not particularly nice people. It would be my kind version of them, but the QC opened up by saying to the two brothers after that, "You disgust me, your avarice is appalling, you have behaved disgracefully."
Was this her
you
client?
Should not even be here. No, not her client,
Okay.
it was the other clients.
Okay.
And there was shock and awe. I thought it was absolutely brilliant because they were conceited, revolting people who were trying to steal money, and she gave them the ultimate reality test at the beginning. It was stunning. And the last involves your former guest and Deborah Chambers, Lady Chambers QC, or KC now, where I did a mediation for a former client of mine. And I said, well, I can't do that mediation to them both because I acted for this man. And they said, we all know that. We have to have you. I said, okay, I'll do it. And I went along, and I think I had got him out of his first marriage into the second marriage, and I think he was on his fourth. But he was wealthy and you know, fine. Lady Deb and Vivian started. They did their legal summary. It wasn't case by case, it was paragraphs of cases to paragraphs of cases, and it went on for about 20 minutes. It was conducted in the most professional way, of course they're both very professional. It was remarkable, and when they finished I turned to the husband and the wife and I said, well, I don't know about you, but I'm terrified. And they said, we are too. And we settled at 3 o'clock that afternoon. It was the most professionally conducted mediation by those two superb lawyers, and it was remarkable.
Laid it all out and enabled everybody else to step back and say, okay, what do we do about it now?
I don't want to say it's a coincidence, but all four of those lawyers were women.
Yeah.
We hate to point out those coincidences too. Do you have any examples of sorts of behaviours that regularly upset you by lawyers as a mediator, and what do you do about it? Lawyers handling a mediation particularly badly.
I think that the only really one is the point I mentioned earlier about don't anchor. Don't put yourself in a position just because you think your client's going to love you. If you stick and fight for them totally. It's not about fighting, it's about finding a pathway that you both sides can accept. It's always mutual dissatisfaction, and really in that way, apart from the odd conclusion, the odd case, which someone does particularly well in because for reasons that sometimes we won't even know about. I think the important thing is, do not just parrot your instructions. You're there to advise your client to move. And please, please be up to date with current law and trends. It's I had a mediation late last year with a lawyer acting for a client, and he simply just had no idea of relationship property law at all. Absolutely appalling. And so bad that I had to have a talk to him and say, look, you're just completely out of touch with the law, and you're going to destroy this. And he said, well, how can I know that? And I said, well, I've got a vague idea. And we talked a bit further, and then he went back, and anyway, we got it settled, but it was most unsatisfactory because he just didn't know what was
Can I slip in a couple of
extra
extra questions? Like, as a mediator and a former family court judge, how do you feel when lawyers explain to you law that you either made or have applied as a judge? Like, should they, how do you feel when they do that?
That's never really come up, to be fair, Shelley. No, it's not really come up. I mean, the law's the law.
Yeah.
If you're practicing family law, you're meant to know a bit about it.
Yeah.
In the cities you do, and actually you have better lawyers basically in provincial centres than the city. The city you have the very best and the worst. In provincial centres you get a lot of really good lawyers. I mean, you talk about Whangarei in the north, I can talk about Hawke's Bay, but provincial centres have the problem that their quality of the lawyers go up and down more regularly, because you can have a very good lawyer that leads the bar and they get appointed to a bench somewhere, and then the standard drops in a provincial centre, but it's better.
Okay.
And do you have to be super rich to do a mediation?
You've got to be a heck of a lot richer to do the court proceedings. Court proceedings, look, that's a fascinating question. Just yesterday, I mediated a matter, and we had just that sort of issue. The legal cost to the parties, they were going for, their first backup was in a month's time, a backup case, in a month's time. They had, by that stage, collectively spent $230,000 with their lawyers, and the lawyers anticipated that to get to the High Court stage, because whoever lost in the District Court would inevitably appeal, would cost them at least another $150,000. So they were about $400,000. Mediation costs.
10.
You've got your lawyer's costs to prepare for it, which are always unquantifiable, and I have an agreement which tells you what the cost is.
That's
but
fixed.
it's I don't know the maths. My maths has never been that good, but it's an awful, a heck of a lot less than that.
That's I mean, I think that's undisputed, isn't it? Yeah. Okay. Are there some?
Let's put it this way: they're in the six-figure range. I'm in the very earliest fives.
Are there some aspects of mediations that can disadvantage a party, and what can you do as a mediator to guard against that? Is it possible?
No, it's not possible, because you never know what those things are going to be until you come to the meeting. I never meet clients in advance of a meeting, and I've had a lot of arguments, discussions with other mediators about that. I find that the theoretical mediators say that you should. I never will, for the very simple reason that if I meet you in advance and we talk about matters, and then
you won't get attached to shit.
and then I meet Tom, for an example, and I talk with him in advance of the mediation, and I go into the mediation, and Tom says to me, "Oh, but you didn't tell me that. You told me this when we spoke," and you immediately think, "Well, he didn't say that to me. Well, where is my credibility? It's gone instantly." So I only talk to the parties together, either together or with their lawyers, or with one party and their lawyer, and maybe other advisors, because I have a lot of accountants who come in with valuation work and valuing Section 15s and all that sort of thing that we have to deal with. You've lost your credibility, and if you've lost your credibility, I am certain, I don't know because it's never happened in that way, I'm certain you'll never get it back in the day.
I'd say so.
So I never do. And that's the, you can have people entrenched and you can do these things, but I would never do it without having the other lawyer present. I'd never say to you, "Look, you should just go, can it, this isn't going to work." There have been cases where that's happened, without a doubt, but you've got to go to the lawyers, and normally I would talk with both lawyers and say, "Look, is this just utterly futile?"
Right, so that's
Funnily
moving
enough, when I think it's utterly futile, is when you often get the breakthrough, and one lawyer says, "Well, we'll do this." Yesterday we were arguing over either $30,000 or $400,000 or $450,000, I think it was, and we settled almost at the midpoint. And we didn't start to move until 4 o'clock in the afternoon. By 5 o'clock we had the numbers, by 8 o'clock it was written up.
Yeah, I think we had a similar experience, and the night before I rang my lawyer and said, which is the Henderson Reed, Stuart, and said, "We're $1 million apart. This is a complete waste of time. I'm not doing it." and he said to me, a mediation is actually never a waste of time, even if you don't settle on the day, which does come up to the next question, which is walking away from mediation must be a pretty difficult thing to do because you're totally invested in the outcome all day. Would you ever suggest to a party not to settle because you'll do better in court?
Yes, I have.
Okay.
But only via lawyers.
Yes.
Only talking with the lawyer and saying, look, actually the one process I think that I've noticed more than ever now is lawyers call to banking. And call to bank.
Yep. Can you tell us?
And call to banking means simply that you set a mark, and if the other side doesn't achieve what they think they'll achieve, they're responsible for your legal costs going forward from that point in time. And there's been a lot more call to banking I've noticed in the last year than ever before.
And that's a good thing because it focuses the mind?
It focuses the mind very quickly. If you're arguing an impossible case, but you're doing it because you're not thinking clearly and your client's
not ready to
move or any of those issues, and there's a vast range of them, certainly focuses the mind because you know that the lawyer on the other side's hourly rate's just going up.
Yeah. Okay, you've been involved in lots of judicial settlement conferences. That happens in a court context. It's free, but are there disadvantages compared to your sort of mediation?
Yeah, I think there's quite a few disadvantages. First, you can never give a final, definite decision.
The judge
because it can always be appealed. So even if you go to a judicial settlement conference and you agree to things, there's nothing to stop you reversing things later on and saying, no, I've been thinking about that. The judge got that wrong. He shouldn't have led us there. Shouldn't have done this. Shouldn't have done that. That's one thing. Whereas in mediation, it utterly is final. And some judges didn't know that, and they've applied they've approached things in a different manner. But in fact, if you get into mediation, that is just what it is. The second is that judges are overloaded. Our judges are incredibly overloaded with work, and I would be very surprised if many judges felt they had adequate time to prepare for
that sort of thing.
A settlement conference that would deal with that, and also they would not be allocated the time they need. And it's very important to know that my mediations invariably take a day. Obviously there are some that have done that taken 5 and 6 days, but very rarely under a day, where you don't get that allocated to you in the court system. You get sometimes 3 hours. It's pretty hopeless. I broke the rules and just allocated my own time. Well, I could do it because I was in provincial centres and in Christchurch, where they wanted me to come to resolve civil conferences. So that's where it's at, really, I think.
Great. We're going to have to skip our last question, but we're going to move on to the quick fire question round. Right. So that's quick fire question time, 10 questions, 10 seconds each to answer them. And Shelley's going to go for the first 5.
Okay, what is the worst thing that can happen in a mediation?
Someone collapse.
Okay, what is the best thing?
A settlement.
What makes a great mediator?
Ability to listen.
Ability to listen. What can you do if the other side won't mediate?
Can't do anything because I don't set the mediation, only the parties, only the lawyers.
What can we do if the other side won't mediate?
Tell them you're going to court. It's the only option.
It is, isn't it? If you could travel anywhere in time, what dispute in history would you mediate?
Should have given you some warning with that one.
Julius Caesar and Brutus.
Oh, I love it.
What did you want to be when you were little?
I wanted to be a train driver, I think.
When you were a judge, what's the funniest thing anyone ever said in your courtroom?
I can't answer that. I just can't.
Okay. What is one change you would make to the family court system?
Abolish and rebuild.
Okay,
Wow,
the big
okay.
one. We'll have to get you on again with
Yeah.
your thoughts on that. Who is the most interesting person you've ever met?
Present company excluded.
Obviously, yeah.
Nelson Mandela,
Ooh.
one-on-one for an hour and 20 minutes.
Oh.
If someone walked out halfway through your mediation, would you A, begrudgingly admire their audacity, B, chalk it up to the hurly-burly of mediation, or C, make sure you let their tyres down of their gold-coloured Nissan Patrol next time you see them?
None of the above, but send my invoice to their lawyer.
What is the best thing about your job?
Truly, it sounds revolting, or it sounds precious, really. Helping people get out of a jam. It's the most amazing feeling. I don't get much feedback. This is going to take more than 10 seconds, I'm sorry.
No,
I don't get much feedback.
Yeah.
And most of the feedback I get comes from women. And it's always lovely to receive because you know you've helped them make a real positive change. Lawyers, as you both said earlier on in your introductory comments, are always sometimes a bit miffy, I think the word was used, about the result achieved. Very rarely are the parties miffed. They get over it. 3 days later, the world the sun comes up again.
Do you remember the end of my mediation?
I remember part of it.
And where Damon and I hugged at the end of it. So we had the first time we've been in a room for a number of years. Yeah.
And that's not uncommon.
No, exactly. That's
It's not uncommon.
and that must feel good, I guess, from your perspective.
We've
see that
We've talked
repair.
about some lawyers in this,
Yeah.
and you've had Vivian Crawshaw on this podcast program. I always remember a mediation where that occurred,
Yeah.
and Vivian and I looked at each other, and I think we had absolutely mirror emotions.
Yeah.
We knew how important
Yeah.
it was for those people, and we knew that as professionals, all of us, the professionals,
You'd helped.
had got them there. It's never just the mediator.
No.
It's vital. The lawyer's assistance is vital.
And you're seeing the two people there, but what they've got behind them is children and family, and the change that makes
And
to their
parents.
and parents.
So to wrap it up for the day, we have our section called The Best Question Ever, and for you, Tony Lendrum, that question is, if you could go back and give 20-year-old Tony some advice, knowing what you know now, what would it be?
Start mediating 10 years earlier.
Ah.
If you're going to be a lawyer, Tony,
Yeah.
start mediating as early as you can. You'll struggle to get the work to start with because they like a bit of grey hair. They think it gives you some wisdom or something. You need life experience. But being a mediator has been, in a professional sense only, of course, the best thing in my life.
Awesome. Well, thank you so much, Tony. That was that was an awesome and enlightening discussion, and I look forward to being in mediations with you in the future, hopefully. And
Not personally, though.
hopefully not personally. Look forward to never being in a mediation with you personally. Thank you for coming today.
Well, thank you both for inviting me.
Good to see you again.
Yeah.
This has been Divorce Cafe. If you enjoyed this episode, check out the other episodes and related topics, and look for the content that's on the links next to the website for articles and ways you can learn more about mediation. Thanks very much. That's a cut.